Hello viewers, I am Dr. Manoj Sharma. Today we shall be discussing the topic Economics of Wide and Voidable Agreements. Let us introduce. Justice mandates that individuals who have engaged in negotiations and entered into an agreement be held to their agreements unless it can be demonstrated that their consent was compromised in some manner. As Lord Scarman puts it, justice requires that men who have negotiated at arm's length be held to their bargains unless it can be shown that their consent was vitiated. Yet, the realm of contract law is fraught with challenges. Many times, contracts are assailed on numerous grounds, including but not limited to consent being flawed, incompetence of parties, or for various other reasons. Accordingly, the legality of a contract may be challenged on grounds like incompetence of parties, lack of consent, illegality of object, want of consideration, etc. Hence, in these cases, the parties are able to avoid the contract. The terminology surrounding such flawed contracts as void, voidable, and unenforceable is notoriously elusive. This issue becomes glaringly apparent when one observes the persistent confusion in court opinions, statutes, scholarly articles, and contractual drafts. The meanings of these terms, while seemingly straightforward, often reveal loads of ambiguity. In practice, litigants are frequently caught off guard when a court redefines a transaction previously deemed void into something less definitive, such as voidable. The distinction between void and voidable contracts has long been a point of contention and confusion for judges and legal practitioners alike. While some may downplay this distinction as a minor detail, it holds significant weight in the outcomes of legal cases. The interchangeable use of terms like void, voidable, invalid, and unenforceable further increases this confusion. Although these distinctions may seem academic in many scenarios, they become critical in certain cases, particularly when determining the enforceability of contracts affected by duress, fraud, misrepresentation, etc. The core of the debate often revolves around two primary approaches, a formalist view and a functionalist view. The formalist view advocates for precise definitions and rigid application of terms, aiming to minimize ambiguity in legal proceedings. In contrast, the functionalist perspective emphasizes understanding the underlying principles and concepts rather than fixating on object terminology. This distinction gains importance in cases where contract flaws arise from coercion, deceit, or criminal activities. The difference between a contract being declared void or voidable can have substantial implications, especially concerning the rights and title of good faith purchasers involved in such transactions. The functionalist approach might argue that understanding the essence of these terms is more important than the precise labels, while the formalist approach insists on clear definitions to ensure consistency and predictability in legal outcomes. In sum, the ongoing struggle to delineate between void and voidable agreements underscores a fundamental issue in contract law. This confusion not only complicates legal interpretations but also impacts the equitable resolution of disputes involving contractual integrity and the rights of third parties. Recognizing and addressing these issues is essential for advancing clarity and fairness in contract law. Now, let us differentiate between void and voidable titles. Before we proceed further, it is important to define the concepts like void and voidable agreements. Contracts of sale of goods involving coercion, mistake, misrepresentation, fraud, incompetence of parties, impossibility of performance or theft, etc., may be classified as either void or voidable. A void agreement is legally non-existent and binds no one, making any goods exchanged under such a contract returnable to the rightful owner. In contrast, a voidable contract allows one party the option to affirm or invalidate the agreement, potentially granting good faith purchasers a valid title to the goods acquired. For example, there is an agreement between X and Y for sale of mobiles. X has supplied the mobiles to Y, and when the time comes for payment of consideration, Y argues that the consideration fixed in the contract is excessive because he was led into payment of the agreed amount on the ground that the quality of these mobiles is at par with the international brands like Apple, whereas X claims that he never claimed that the mobiles are comparable with Apple. He instead claims that mobiles are comparable with another brand, that is Maple. The contract thus is hit by flawed consent. The legal treatment of contracts tainted by duress, fraud or misrepresentation, undue influence, mistake, etc. hinges on whether they are deemed void or voidable. This classification is vital for determining the rights of good faith purchasers and underscores the importance of free consent in contract law. The rights of the parties would be different in cases of void and voidable contracts. For example, if consent to a contract is obtained by fraud and the party whose consent was so obtained decides to affirm his or her consent, then the contract is valid and the other party is bound by the contract. Similarly, the third parties are those who have acquired right, title or interest in the contract without knowledge of any flaw in the contract. However, in the case of a void contract, the contract being non-existent, it does not create any right, title or interest in the third party who purchased the goods in good faith. The distinction between void and voidable contracts is crucial for good faith purchasers as it determines the validity of their title to the goods. A purchaser buying goods under a void contract lacks a valid title and must return the goods if the original owner demands them. Conversely, a purchaser under a voidable contract can secure a good title, protecting their interests in the purchased goods. Section 14 of the Indian Contract Act defines free consent, listing 5 specific factors that can vitiate it. These factors are exhaustive, suggesting that no other cause can legally undermine the consent between parties. Consequently, even if the consent is not freely given. It is presumed to be free under the law if these specific factors are not present. The interplay of duress, fraud, misrepresentation, etc., with contract law significantly impacts this distinction. In India, the Indian Contract Act 1872 defines terms like void and voidable contracts, and also the situations when a contract is void or voidable. Coercion or duress, fraud, misrepresentation, and undue influence make the contract voidable, whereas a contract may be declared void when the consent is caused by a bilateral mistake or when the contract is flawed due to the incapacity of parties, etc. Now let us move to discuss factors causing the contracts to be void or voidable. First of all, coercion or duress. Duress is referred to in the Indian Contract Act 1872 as coercion and is defined in section 15 of the Act as committing or threatening to commit any act forbidden by the Indian Penal Code, or unlawful detaining or threatening to detain any property to the prejudice of any person with the intention of causing any person to enter into an agreement. The Indian Contract Act, therefore, recognizes duress as a factor that destroys consent and declares such contracts as voidable. Let us take an example. X forces Y to enter into a contract. He threatens that if Y does not enter into a contract for supply of sugar with him, he will not pay the long outstanding dues. In order to recover the previous debt, Y agrees to the deal if the consideration of the deal is paid in cash. Here, the consent of Y is obtained through duress, and hence Y has the option of avoiding the contract. The contract cannot be enforced by X. However, if Y decides to abide by the contract becomes enforceable and will create rights, titles, and interests. Duress thus occurs when unlawful pressure is applied to compel someone to enter into a contract. This pressure can manifest as physical or economic duress. There is a need to differentiate between economic duress and commercial pressure. A continual challenge in the legal arena of economic duress is the need to distinguish it from mere commercial pressure. In the commercial sphere, the concept of commercial pressure often stems from an imbalance in bargaining power between parties. Generally, courts are reluctant to question the validity of contracts that arise from commercial pressure or business compulsion. This hesitation is grounded in the practicality of life, that perfect equality in bargaining power is unattainable, and mere discrepancies in bargaining power alone are not sufficient grounds to invalidate an agreement. Nonetheless, there are instances where the disparity in bargaining power is compounded by improper conduct and ulterior motives, which can undermine the genuine intention of the parties involved. In such cases, it becomes crucial for the judiciary to intervene and safeguard the sanctity of contracts. In the context of Indian contractual law, the concept of economic duress is implicitly recognized under Chapter 2 of the Indian Contract Act 1872. Although the Act does not explicitly mention economic duress as a vitiating factor, a liberal interpretation of the provisions suggests its inclusion within the scope of Chapter 2. Case law reveals that Indian courts have not established a universal rule for economic duress. However, the Indian legal framework often borrows common law principles, and economic duress is interpreted almost similarly as English courts handle it. The legal doctrine posits that duress, including economic duress, is essentially a form of coercion that vitiates consent. For economic duress to be established, two conditions must be met. First, the pressure must be compelling enough to force upon the victim's will, and secondly, the pressure must be illegitimate. This interpretation aligns economic duress with the concept of coercion under Section 15 of the Indian Act, expanding the understanding of coercion to include illegitimate economic pressure and lack of practical choice. A key question in the discourse on economic duress is whether it can be considered an unconscionable bargain under Section 16 of the Indian Contract Act. The case of Puri Construction Private Limited versus Larsen and Toubro addresses this issue, concluding that economic duress can indeed be categorized as coercion. This is particularly important when one party dominates the other's will to gain an unfair advantage. However, to invoke Section 16, subsection 3, it must be proven that one party has apparent authority over the other, creating an unequal power dynamic. Thus, while economic duress can be seen as a form of unconscionable bargaining, its application is limited to situations where there is a significant power imbalance between the parties. Indian courts have also broadened the scope of economic duress by incorporating it into the public policy exception under Section 23 of the Act. In Jaipal versus State of Haryana, the court noted that transactions resulting from economic duress could be deemed unenforceable on public policy grounds, even if traditional elements of coercion or undue influence are not present. This suggests that economic duress is a broad concept that can impact the validity of a contract beyond just issues of consent. In practical terms, economic duress renders a contract voidable rather than void. This distinction arises because duress impairs consent rather than nullifying it altogether. A party affected by economic duress may still opt to uphold the contract, possibly renegotiating terms once the illegitimate pressure is removed. Although economic duress and commercial pressure are connected concepts, judicial efforts have been made to differentiate between them using specific criteria. One of the earliest attempts to address this issue was the development of the coerced will or overborne will theory, which emerged from a series of cases. This theory posits that commercial pressure can invalidate a contract if it effectively coerces a party's will to consent. According to this theory, the key factor in distinguishing economic duress from mere commercial pressure is the voluntariness of the plaintiff's consent. The consent must be such that the plaintiff is deprived of their freedom to choose. Even if the plaintiff's consent appears to be given, it is not deemed voluntary if the pressure is so overwhelming that it impairs the plaintiff's freedom of will. However, this criterion proved to be somewhat crude. The concept of voluntariness introduced more confusion than clarity due to its subjective nature. Critics argued that this test was essentially a modern adaptation of the old duress test applied to commercial contexts. Nevertheless, the effect of physical or economic coercion remains the same, in the sense that the contract in such cases would be voidable at the instance of the forced party. The economic principle for declaring such contracts voidable is the involuntary agreements do not promote exchange and do not create surplus. Now let us see the fraud and misrepresentation. As per the Indian law of contract, a contract is vitiated by fraud and misrepresentation. The difference between fraud and misrepresentation in Indian law is that in the case of fraud, there must be an intention to deceive, whereas in the case of misrepresentation, there is an incorrect statement without any intention to deceive. The party whose consent has been obtained by fraud or misrepresentation has the option either to insist on the performance of the contract or to avoid the contract, since such a contract is voidable. Unless avoided, such a contract is enforceable and a purchaser in good faith and for a valuable consideration acquires a good title to the goods. This provision aims to facilitate commerce by ensuring that good faith transactions are upheld despite underlying fraudulent circumstances. Similar consequences would follow in cases where the consent is obtained by undue influence, wherein one party uses its dominant position to dominate the will of the other party. The economic reason for not enforcing a contract at the instance of the party who has committed a fraud is that if the other party knows that fraud is a ground for avoiding the contract, it can depend upon the statements made by the first party. This would save a lot of time and money in verifying the statements made by the first party, leading to a decrease in the cost of concluding contracts. Hence, there is an economic efficiency principle in declaring such contracts as voidable. Now let us move on to discuss mistake. The effect of mistake on a contract is different than the effect of duress, fraud or misrepresentation. In cases of bilateral mistake, that is, where both parties are at a mistake, there is no voluntary exchange. Such contracts are void contracts. Involuntary exchanges do not promote cooperation and do not create value. Instead, they can destroy the value. Hence, such a contract is void and unenforceable under the law of contracts. Let us take an example. A has two watches of the same brand but of different value. Suppose the value of watch 1 is rupees 2 lakh and the value of second watch is rupee 1 lakh. He offers to sell his watch to B for rupee 1 lakh and B accepts the offer, believing that he is buying watch 1 whereas A intended to sell the second watch. Now here both parties are under a mistake while they entered into the bargain. In the instant matter, if the contract is enforced and A is compelled to sell watch 1 for rupee 1 lakh, the exchange would destroy the value of the watch and create a negative surplus of rupees 1 lakh. In the instant matter, the contract cannot be enforced because the law declares such contracts as void and thereby avoids the destruction of value due to involuntary exchange. However, the position would be different if the mistake is not bilateral but a unilateral mistake, where only one party is under a mistake. For instance, let us suppose I have a fountain pen that is very old and I want to sell the pen. I know that it's an old piece. B intends to buy the pen because he knows that the pen is not only old but it's a classic. They agree to exchange the pen for a value. Here, the seller is mistaken about the value, but the buyer is not. And this is the classic case of unilateral mistake. In case of unilateral mistake, the contract is enforceable. Section 22 of the Indian Contract Act declares such contracts to be enforceable and not void. From an economic perspective, in a contract where there is a bilateral mistake, the exchange is involuntary and hence such exchanges do not create value. Instead, they destroy the value. However, in cases of unilateral mistake, there is an incentive for discovery and knowledge, and hence such contracts are enforceable. Now let us discuss impossibility of performance. A contract may be enforceable when entered into, but it may become impossible to perform due to the happening of a certain event. Let us take an example. X agrees to play guitar for Y at his wedding, and a contract is entered into. However, a day before the date of performance, X meets with an accident, whereby his hand is broken. The contract becomes impossible to perform. What will be the legal consequence of such a contract? As per Section 56 of the Indian Contract Act, such a contract is void and is not capable of enforcement due to impossibility. The object of declaring such contracts as void is their impossibility, but what about the allocation of the cost associated with declaration of the contract as void? The economic principle would require the apportionment of the risk associated with impossibility of the contract to a party who can bear it at the least cost. Now let us proceed to discuss incompetence of parties. The contracts where one or more of the parties are legally incompetent to contract are declared void. Under the Indian law of contract, minors, persons of unsound mind, are not legally competent to contract because they are not in a position to make a real voluntary exchange. Such contracts are void and hence unenforceable. The economic principle of such contracts being declared void is that such contracts do not promote cooperation and do not create surplus. As per the economic analysis of law, the risk associated with such contracts must be assigned to the party who can bear the loss at least cost, and accordingly, the party who was competent to contract is deemed to be the party who can bear the loss at the least cost. That is why Indian law declares that such a contract cannot be enforced against persons incompetent to contract. Similarly, contracts where the consideration or the object is illegal, the subject matter is illegal, there is no consideration, etc., are also declared void based on the above economic principles. Now let us conclude the topic. The distinction between a void and voidable contract is important for determining the legal consequences of the contract. Voidable contracts can be enforced at the instance of the party whose consent was not free, whereas void contracts are unenforceable. However, classifying and labeling contracts as void or voidable by applying legal norms is very complex. The legal field has long struggled with the simplistic classification of all invalid contracts as void or voidable. While these terms serve as convenient shorthand, they often fail to capture the complexity of why a contract may be invalid. Without a deeper understanding of the theoretical basis for these classifications, professionals risk continuing the unpredictable practice of labeling contracts on a case-by-case basis. That is it for the time being. Happy learning. God bless you.